Good morning. Good morning to everyone joining us at this very, very important event this morning from Tax Debt Compliance. The title of our discussion is to stop the unknown stress about SARS related to the tax debt collection process. What we know is that this true process is not very well known to everyone out there. So this morning, we're really excited to welcome you and to bring you a full overview of this process, that you can understand what it's about and that you can apply it with your clients and learn more about the process. Our speaker this morning is Gerard Linde. He holds a master's degree in taxation from the University of Pretoria. He's a chartered tax advisor, and this, of course, is a leading designation from the South African Institute of Taxation. It's an internationally recognized and respected award or a designation, and it's a mark of his technical superiority and professionalism and integrity. So Gerard is the director at Tax Debt Compliance, and Tax Debt Compliance specializes in assisting businesses and individuals who are non-compliant with SARS to become fully compliant. Gerard is specialized in this area over the last 7, almost 8 years, and he's dealt with 200,500,000 Rand in total tax debt and reduced that to 50 million Rand in total tax debt payments. That is actually a total tax debt reduction of 75%. And the biggest tax debt reduction for a tax debt compliance client was 97%. So at Tax Debt Compliance, we have 100% success rate. What does that mean? It literally means that none of the clients who have put their trust in Tax Debt Compliance have lost anything owing tax to SARS. So Tax Debt Compliance is compliant to the South African taxation law and acts as a link with you and your customers to negotiate with SARS. So without further ado, I'd like to introduce Gerard to you. And Gerard, we're really looking forward to this discussion this morning. Thank you.
Thank you, Dalian, and good morning to everyone joining. And we are recording, so anyone watching a bit later, so welcome to you. We hope this session is a bit informative. It's going to be very quick and to the point, cover the things that we're going to cover this morning. And this morning we're focusing on the tax debt collection process, just to understand what does each one of them mean and where do you fall within this collections process, so that you know what's the next step or what to expect. Sometimes it's a bit unknown or where you are. So I just would like to touch on the few steps that are available. We did sit with a SARS official, discuss some of these things. Some of them is directly from that source. So we did verify, because sometimes the act's not completely clear, and then what happens in the act and in practice is a bit, it's not always the same, or it's not as explained in the act because of the practical things that SARS do. So let's just jump straight into it. Our discussion outline for today will be the steps, which will be your initial engagement from SARS, your final demand, your third-party appointment, the civil judgment, and then onto the warrant of execution. Thank you, Dalian. We could just hop onto the first slide, which is your initial engagement. Onto the next one. This is just your courtesy engagement from SARS, which is not covered in the Act. This will mean someone from the call center will phone you or try to email you and say there's debt on the account, and they would like to know, when are you going to pay and how much are you going to pay. So this is not covered in the Act, like I said. So from their side is that this is a good, they're reaching out to you as a courtesy just to see, can we work together? And they just give you roughly about 5 working days. So this is not a set working days, like I said, when it's not covered. So this is just a practical way that they operate. Obviously, they will make use of the latest information that is on e-filing registered. So they would use that information to get into contact with you. So if that's not up to date, they would not be able to do that. And that means that from their side, that it's marked as they try to reach out, and then they will move on to the next. So this is one of the very important aspects of the collection process, is to make sure that the details are updated. So tax practitioners obviously take responsibility in updating, but also very, the responsibility is with the business owner to make sure that they are aware that the details need to be correct, because there's where all the correspondence go to, and then you can't use the excuse that you did not get the information, because it's not SARS's mission to make sure that your details are correct. That is your responsibility in full, which will cause a lot of trouble as we move through the steps, because that means you will not receive the correspondence. You will not know where in this collection process we're in. And a lot of times we've had clients saying, we didn't see a demand, but we didn't see this civil judgment. I just went on the system. I tried to get a loan somewhere, and then they informed me that I have a judgment against my name. And in most cases, that's because the details are not updated. So after the courtesy, we're going on to the next one, into the final demand. This is covered in section 179, sub 5 of the Tax Administration Act. And then if no payment is received after the initial courtesy call, SARS can issue and will issue a final demand. Now, this final demand mostly will happen through e-filing, but they can also be sent directly from a SARS official who is a debt collecting agent. But mostly it will be through e-filing. So this is the very first step in the collection process, which means this opens the door for them to move on to all the next steps. As per the Act, you have 10 working days to respond to this letter. And if you do not respond within 10, then they have the opportunity to move on to the next collection step. And so I just wanted to touch on a point in terms of final demands. I believe most of you, all of you would have seen that there's constant final demands being sent through e-filing. So even when we are dealing with clients, we've addressed an issue, we are applying for a compromise of deferment, the final demands keep coming through. Now, the reason that I obtained from the SARS official is that they keep issuing these demands so that they do not lapse 6 months. So it means that if the final demand is older than 6 months, that SARS cannot take any further action. So that's why the demands are issued, so that the demand will show as recent, and that will open the door for them if they want to go on to the next step. So that is why you keep on receiving all these demands, very first step in the collection process. And if we move on to the next one, which will be our third-party appointment. So this follows the final demand. This is covered in the section 179 of the Tax Administration Act. And this is the most common one because it's the easiest way for SARS to source money once the demand has lapsed. And this is the opportunity for SARS to recover your debt from third parties, like as listed here, from the bank, investments, your debtors, or your employers. The bank probably will stand out as the easiest one to attach. So they would send a letter of a third-party appointment covered in the Act, and the bank will have no decision or option to withhold funds from SARS. So if there is money in the account, they will deposit that money straight to SARS. So just to use an example, if SARS issues a third-party appointment of R1 million, and if there's R1 million in the bank, that will be sent straight to them. So without your consent or even notifying you. So the bank will do that directly. Then the other one, in terms of individuals, the employers are probably the easiest one. They issue a third-party appointment in terms of the garnishee order against your salary, and that will get deducted automatically each month from the individual. Just a side note that we got from the individual, it's covered in PAJA, if I understand it correctly, that the garnishee order cannot be more than 25% of the salary. So if you have clients that is garnishee, just check that amount is indeed 25%. It might be less in some cases, but it just can't be more. So that steps will be used by SARS exhaustively in terms of the recovering. And if they feel like the bank attachments are not going anywhere, they can go on to the civil judgment. So again, you have your 10 working days to respond to the third-party notice. And then after that, we'll go straight into the civil judgment, which is covered in section 172 of the Tax Administration Act. And then obviously SARS approaches the court to obtain this this judgment. So it's like I said, it's a civil judgment, so it doesn't fall under a criminal matter. So it's not a criminal case, civil, because in terms of collecting money from you, so they're not pressing charges. It's just so that they can collect money on a civil basis. Yeah, SARS, just to explain the civil judgment and the workings, SARS has an expedited route to the courts, which means that they can obtain this judgment very quickly. So it's not they have to go through the whole process. They almost, if you want to call it, have an in with the courts, so they can obtain this judgment fairly quickly. Again, as per the Act, you have your 10 working days to respond. And if you do not respond, then SARS has the ability to obtain this judgment. And that's where a lot of issues comes in terms of once you have the judgment against your name, SARS, you'll struggle to obtain any sort of credit. And that's mostly where taxpayers find out that they have an issue because it's listed on their credit score that there is a civil judgment. In terms of removing the civil judgment, that can only be removed once the debt for which it was taken is resolved. Just a side note on the civil judgment. So let's say judgment was taken for a specific amount and period, and you've settled, and now there's new debt or other debt outside of the judgment. Sometimes SARS will tell you, well, you have to sort out everything and pay up everything before the judgment is removed, which is incorrect. As long as the amounts and periods which were covered in the judgment was paid, SARS needs to remove the judgment and then start the collection process again. So just so that's a fairly technical point, but which they love to use, but it's not correct always. So important to note that if you're dealing with a debt, just to establish, for what periods was the debt taken and was it paid? Because sometimes SARS is a bit slack in removing judgments. You might have paid the debt, but you will still sit with the judgment. Then we're moving on to the very end in terms of the collection process, which is a warrant of execution, and that's covered in section 163 of the Tax Administration Act. Again, SARS approaches the courts for a warrant and just to attach and sell your assets. So SARS will see, well, they're not making any headway in terms of collecting money from the third parties. And the easiest way for them to recover the money now is from the selling of your assets. So they would move on to your movables first. Those are the easier ones to sell, and then on to the immovable assets. You obviously have your 10 working days to respond again. And if you do not, SARS can get the warrant and then give instruction to the sheriff. So what would happen is the sheriff would come out firstly and then come attach your assets. So they attach almost sounds like they're taking it, but it's not what the attach means in this case. It's like they are coming to write up the assets, so the values, giving a value to the assets in let's call it in the premises of the business, and then afterwards SARS can give the order to attach and remove. So after they've seen the attachment, what the assets are more or less worth, they can give that attachment order and remove order to the sheriff. So the sheriff would come in, collect it. They're obviously responsible to store the assets in a safe place, and then that would be used in terms of settling your debt. And that's basically the process in terms of the SARS collection process. We covered, there's a lot of things that happen in between all of this, and then obviously you would need some sort of remedy in terms of how do you stop the clock on each one of these collection steps. So, if we hop on to the slide where we look at your options that are available to you. So, if you're covering the objections and your appeals in section 104 and 107 with the suspension of payment in terms of section 164, that can stop the clock in terms of disputing the debt that there is. So if the taxpayer is not in agreement with the debt, we need to put in a dispute with the suspension. So the suspension basically means that the Act says that if you intend or are disputing debt, SARS can put the dates aside until the objection or appeal is resolved. It's not a guarantee, but it's definitely one of the options that needs to be considered, because that means SARS cannot collect the date until there is a resolution on it. So the second part to this is obviously if there is no objection or appeal, or you do not dispute the date, so the date is factual, you owe the date fair and square, then you need to put in something else, and those things are covered in terms of the deferment and the compromise. So that is your repayment mechanisms. So once you have an application in, and SARS needs to give you an answer on your application, that puts a stop on the collection clock. Now, it's very important to note that these options are available throughout the collection process, which means in any of the steps that we have listed. So if you've received a final demand and you put in any of these mechanisms, that means they will stop the clock for you. Once they've done that, the taxpayer is safe in that regard. And that can happen at the third party appointment or the civil judgment or the warrant. So it's very, so the SARS cannot tell you, well, it's too late, you can't use these mechanisms now. So these are always available throughout the process. And so it's very important to note that you have these mechanisms to your advantage. And we have covered this in one of our other webinars in terms of going a bit into more details of what does the deferment and the compromise mean for you and what are the options available. So we'll post a link in the chat. So you're more than welcome just to go in and review any of these the webinars that we've covered, just to give you a bit more information on what this means. And that is basically, in short, just a quick summary of the collection process. You're more than welcome to get into contact with us. My email and my phone number is right there. We will have continuous webinars on these as we go forward. If you want to know anything or have any questions, you're more than welcome to pop them in the chat, or you can email them to me. And I hope that today's session was informative. Like I said, it's very quick and easy for everyone just to have an idea of these collection steps and to know what your rights are as well. So thank you to everyone who joined. I hope this was very informative. Please give us some feedback. And if you have any other questions, we'll be on here for a few minutes. If not, thank you for everyone who joined. We appreciate your time, and we hope that today's session was very informative.
Great, Gerard. Thank you so much. We will also be sending you the video recording of this webinar that we had today, and want to really encourage you, if you have any questions, you're welcome to type it in the chat box. You're welcome to send it to me personally, quickly in the chat. If you want to send a personal question, we would love to answer them. And then please go onto our website, onto our YouTube channel. Make sure that you connect. There are very valuable answers on there, specifically also on the frequently asked questions part. If we can, Janine, if you can post that link for us as well on frequently asked questions on the website. For more technical type of questions on our YouTube channel, there are various videos that explains the compromise, for example, or the deferment in a lot more detail. So you are most welcome to send your questions in. As I said, we will send you the recording. Really appreciate it, and looking forward to welcoming you into our upcoming webinars as well. Let's see, there's a comment. Thank you very much for that. Thank you. It's informative. We're now equipped to engage with the taxpayers on how to go about initiating a compromise to then get debt compliance involved. Absolutely, Amanda, and I would really highly suggest that. The reality is, and Gerard discussed it in the previous webinar as well, the only way to get this experience to work in this field is to physically do it. There's no formal training for this. So it's very easy to understand the law, however, and the workings of the law. However, the intricacies in this, to understand the process, to put it together, and to know how to do the negotiation on the behalf of the client is where tax debt compliance is very good, and where it's very important to connect with Gerard on this. Remember, your client always stays your client. You don't lose the client It just takes that service and concern off your hands. So Craig is asking a question. Thank you, Craig. And Amanda, thanks for that comment. Are there specific requirements for a compromise? For example, a liquidity test or projections? Gerard, can you please answer that? Thank you, Craig.
Yeah, so thanks, Craig. So compromise is covered in section 200 to 205 of the Tax Admin Act, which gives a guideline of what SARS are looking at when they make a decision on the compromise. So in essence, what it means is, they need to source the most amount of money in the shortest amount of time. And does the compromise provide that to them? So in short, obviously, the offer that you put on the table, is it fair, and does it relate to your financial position? So there's a lot of moving parts in terms of determining a fair compromise. So your cash flow would play a role, your net asset value would play a role. So all of those and the projections of going forward for the company. So there's a lot of moving parts, and each client will be different. So that's what the compromise aims to do, so to satisfy SARS that the offer on the table is fair and that they can't reasonably collect a greater amount by pursuing any of these steps that we've just covered.
Thank you, Gerard. And Craig says that makes sense. Thank you. So if there's no further questions, expect this link with the video of today's webinar in your inbox in the next couple of days. Do go to that first link that we posted on YouTube. We'll quickly post it again for you to understand more about this process that is followed by tax debt compliance in assisting your clients. And you are more than welcome to connect with Gerard directly on his email address, linda@taxdc.co.za, and to go and have a look at our website. So thank you very much. Gerard, thank you very much for the value that you've added. We're looking forward to hearing from you. Interact with our posts on social media, on LinkedIn, on Facebook as well. We've got client success stories on there. Ask your questions, because what we are finding in connecting with clients is very often they don't know that this exists. They don't understand that there can be a negotiation with SARS. And they also don't find a business that they can work with who actually assists them in the right way to make sure that they become compliant with SARS and who works within the law. So thank you very much. Gerard, thanks so much. Thanks for everyone attending. Have a great day.